One of the areas of flu that sometimes is blank has been legislative updates. There hasn't been a whole lot going on with the legislature recently, but there are a couple of things that have occurred in the last month that were mentioned in flu, and I want to talk a little bit about them in today's video. One of them is a bill that's been introduced. It's SB 179 that would eliminate the 6-month waiting period to remarry after a divorce. I don't think it's a big deal, and I think we're one of the very few states that has that, but I take sort of an ironic view of that 6-month waiting period. The purpose of it is to allow parties to resume their marriage, sort of a never mind. And while it is not at all uncommon to have parties file for divorce, and while the process is going on, rethink it, hopefully get into counseling, and sometimes work out their differences and have the case eventually dismissed. And we have that happen fair frequency in this office. It is extremely rare in our experience that after going through all of the disclosure, all of the negotiations and or litigation, all of the process procedure, and all of the costs to get to a final agreement, that at that point parties say, never mind. So the waiting period for the purpose of for people to put aside everything that happened and resume their marriage doesn't seem, in our experience, to work in a whole lot of cases or be meaningful. The 6-month waiting period, though, has, I think, an unintended consequence, which is that it is not that infrequent that people who have been going through a divorce have a significant other, essentially spouse number 2, number 3, number 4, whatever the circumstances are, lined up waiting, and that after the divorce is granted, they're no longer married to their first spouse or whatever the number is, that they begin to rethink being single, being married, and sometimes the new marriage, which was very, very much planned on, never does happen. My point is that while the 6-month waiting period is intended for the purpose of getting the parties going through divorce back together, in what is known as the law of unintended consequences, we find it has a beneficial consequence in some cases of preventing remarriages from happening precipitously. Sometimes given some time to think about it, being single for a while, giving it some thought can have some real value. Therefore, while the legislation isn't necessarily the worst thing in the world, I sort of like that 6-month waiting period. I think it works for people, and personally I would oppose that legislation and think it ought to continue, even though it serves a different purpose from what its original intent was. The other piece of legislation is being proposed actually by the family law section, and it's one with which I have intimate knowledge, not the proposal to change, but the underlying law. About 20-some years ago, I became involved in modifying the removal statute. A lawyer from Racine who passed away a few years ago named Judy Hardig-Osanka, wonderful attorney, had a case called Kirkvalite, which said that courts did not have the power to prevent a move even if it was not in the child's best interests. And Judy and I sort of teamed up to work on the statute. She was interested in the substantive provisions to allow the court greater authority, and I was interested in some of the procedural ones. At the time, there was no specificity, tough word, required when giving the notice of intent to remove. You just gave a notice of intent to remove, and I felt the notice should include when you're going to move and where you're going to move to. And there were a number of other procedural aspects of it that I thought were important. And it took quite a bit of work, several trips up to Madison, quite a bit of lobbying to get it done, but eventually the statute was amended and it's in its current form. And I think it's worked out pretty well, but there are some things that could be improved, as there always are, particularly, to give you an example, when the removal is 150 miles from the other parent, do you have to give notice if you're already living 150 miles from the other parent? The statute's a little unclear about that. When we were involved in it, I thought that it made sense, but subsequently I understand the position that some people would think every time you move, if you're already 150 miles away, you have to do a new notice. And the proposal by the State Bar Family Law section would clarify that. The other aspect of it that's probably been the most controversial in my experience is whether or not the current statute applies to paternity cases or only to divorce. There's actually quite a bit of legislative history to it, because in an original version of what we drafted 20-some years ago, it was designed to apply to paternity cases, and there was a lobbying effort against that. There were groups, particularly a domestic violence group, who felt that in paternity cases there may be a higher instance of domestic violence, and trying to restrict those cases under the paternity law would not be in the woman's best interest, since it's the woman most likely to be granted custody, most likely wanting to move. I wasn't comfortable with that at the time. I felt that it should apply, but politically speaking, we couldn't get the amendment to the removal law passed unless we agreed to remove that provision. Interestingly, I have been contacted numerous times as to what the legislative history is. I was actually once subpoenaed to go to court for that purpose. Fortunately, they worked it out without my necessity. And Judy and I wrote an article for the Wisconsin Journal of Law a number of years ago outlining what that legislative history was, to try to give people some guidance, because it isn't clear. Some counties say it do apply to paternity cases and others do not. One of the nice things about the proposed legislation by the Family Law section is it would clarify that it does apply to paternity cases. I think there's an equal protection issue if it would not. I don't think anybody's ever challenged it on that grounds, but I think it's sitting out there and available for challenge. And so I think the legislation in terms of clarifying the 150-mile rule, clarifying that the removal law does apply to paternity cases, some of its other provisions would be an improvement and clear up some of the gray areas in the current legislation. Much as I like to think that the bill that I worked on is perfect, everything could be improved, and this is one example. Pay attention to flu or each month, if you would, in that section. Hope you pay attention to all of it. And I'll be providing updates on what's happening with this legislation and any other legislation affecting the practice of family law in Wisconsin.